Everyone, and welcome to our program today. This is the practical tax aspects of the Altadena and Pacific Palisades fires. I want to start by thanking Terry Cuff for being a great driving force behind making sure that this program was released and was able to be marketed to a broad range of audiences. This is really his passion, and we're here to support that. And we have some equally passionate people speaking about it because it is a very obviously important area of interest in our local community, unfortunately. My name is Megan Jones, and I'm a tax attorney at Better Price. I do a mix of entity and individual tax. I'm a certified income tax specialist, handle international and domestic and local as well, including California. I want to talk about John Trapani first, and then I'll have Dennis Perez start discussing the program. John I was both heartened and also sad to hear that he's dedicated his practice now just to helping people that are victims of wildfires and other disasters. He's a CPA based here in Southern California, and he's got 30 years of disaster tax reporting. And he can help with a whole range of services, filing tax returns, disaster tax services, consulting services, dealing with lawsuits in this area. Dennis Perez, I'm sure many of you know, he is a partner at Hockman Salkin Tasha Perez. He's also a tax attorney, and I always say that Hockman Salkin is probably the top tax controversy firm in the state. And Dennis is obviously one of the named partners and a very esteemed tax lawyer. He can handle pretty much any type of tax-related or other civil litigation, and that includes dealing with government agencies or just on a broader basis. Dennis has a personal story to share. He has a vested interest in this topic. So I'm going to pass it over to Dennis and let him start, and then we'll bring in John. Thanks for attending, everyone.
First of all, can you hear me?
Yes.
Okay,
Yes.
good. Because it shows me as being muted on my phone. I had to change from my computer to my phone because of connection problems. Anyway, good morning or good afternoon, everyone. It's my privilege to be on this panel with such an experienced tax attorney as Megan Jones, and also with John Trapani, who we really is going to be the star of this program. I don't know of anyone who knows this area better than John, so it's my privilege to be here. But the reason why when Terry asked one of my partners whether we would be interested in participating, I immediately put my hand up, not because I thought it would be good to be providing the service to the bar and also to the local community, but because I have a personal interest, because I am one of those unlucky persons who lost their house in the Pacific Palisades fire. So I've been experiencing much of what many of my neighbors and community members have been experiencing since January 7th. I will tell you that this is the first webinar that I've ever participated in where I wasn't wearing a suit and tie, and that's intentional. I'm wearing what I call my fire sweater. This was a sweater that I was wearing on the morning of January 7th when I went to visit a client at Juicy Ladies Cafe on Sunset, for those people who know the Palisades. And it was at that meeting that I received the be ready to evacuation alert, as did the person I was meeting with. Unfortunately, I never made it back to my house. Immediately called my wife. She saw a wall of flames across the canyon. We lived in the Marquez Knoll area to Paseo Miramar Hill, and she left. So this sweater is one of the few things that I left my house with, and my wife pretty much the same. I wanted to highlight a few practical issues that I've come across, many of which I'm sure you have heard of, but I just want to make sure that everyone knows of these things. First of all, the application for reassessment based upon a loss, damage, or loss to your property must be filed with the LA County Assessor's Office within 12 months of the date of the event. So that 12-month period is coming up. So if you haven't done that, please file. It's a Form A, D as in David, S as in Sam, 820. You can go on the Los Angeles County Assessor's website and you look to the County Assessor Disaster Relief Fact Sheet, and you can then click on the link and get a copy of that form and file it. So please do not forget to do that. I think most people have done it, but recently on Nextdoor, I saw that somebody was asking about this. So I want to make sure everyone knows about that. Also, for those people who are not planning to rebuild, um, and if you sell your lot and buy a replacement home somewhere else in California, be sure to look into Prop 19, which is codified in Revenue Tax Code 69.6, and that allows you, if you are more than 55, allows you to transfer your base value, your base year value of the property that was destroyed to a new property. Just wanted to highlight that to you. I can't tell you the procedures, but certainly look into that if you're selling your lot. Wanted to make a few comments about debris clearance. My friend Steve may be attending this with his wife, Mary Ann. Steve and I were talking an awful lot soon after the fire occurred about, gee, should we have the Army Corps of Engineer clear our lot, or should we go with a private contractor? And after an awful lot of research, mostly by Steve, what became clear to me is if you had the Army Corps of Engineers clear your lot, clear the debris from your lot, you had to, as most people know, you had to file an opt-in form, and that opt-in form required you to provide your insurance information. And so, a couple of points on that. I can tell which lots were cleared by the Army Corps of Engineer because a lot of them have hardscape and sometimes foundations still on the lot, because they made very clear that they would not be clearing hardscape. Also, I can tell that there's been a lot of dirt taken from the lot. So if you went with the Army Corps of Engineers and you had insurance coverage, what I've been told by my adjuster and by other people is that the Army Corps of Engineers, when they tap into your coverage, they'll take everything. If they take everything, then you'll have to reach into your pocket to cover the cost of clearing the rest of the hardscape and perhaps foundation, and perhaps even bring dirt onto your property before you can build. I don't know when the Army Corps of Engineers will do that, but I would say the sooner you get it, you have yourself a clear lot so that your contractor can rebuild your house, the better, so that you can use those funds before the Army Corps takes whatever they're going to take. And I've been told they take everything.
That's very helpful.
Yeah, so that's all I have. I think let's start with John's slides and continue.
And we're going to try to take questions if possible during the program, but we have a lot of material, and as John jumps in, you'll see he's very detailed in the information he's providing. So feel free to reach out to any of us after presentation.
Well, good afternoon, everybody, and thank you for attending, and thanks to the Bar Association for taking the initiative to put on this program, and also my co-panelists for giving their time. So while it's obvious that thousands of homes have burned in the recent fire, and even more have burned in recent fires over the last 5-10 years, it's still possible that as a practitioner of tax, that this is your first time that you're having to deal with one of these situations. It's not uncommon. These are very unique, and I guess the uniqueness is, I think, punctuated by the fact that here we are doing a special presentation, and here you are doing a special listening. So I do want to emphasize that what we're going to be covering today in many ways is just a glimpse of all of the aspects of dealing with the income tax aspects of these situations. There's just so much that we could pack into a 1 hour presentation. Um, um, skip ahead here. Um, the process of recovery involves three steps. One is settling your claims, getting everything done, and dealing with the counties and all that stuff. And the second part is rebuilding your family as emotionally as necessary, and also rebuilding your property, replacing your property. But there is one remaining responsibility, and that's disclosing all this to the IRS and Franchise Tax Board. I want to emphasize the word disclose as opposed to report, because report implies taxation, and disclose and means we're just telling the story. And of course, there's two stories that we could be telling. One is a possible casualty loss, in which case there is a reporting, and the other is an involuntary conversion. And we'll get into that. There are multiple different kinds of properties that are dealt with in the tax code. And just in summary, for our purposes today, to think about the four big ones are the primary personal residence, a second home, which they're different from a primary personal residence in terms of the way they're handled. The third is rental property, and the fourth is commercial property. So commercial property and rental property are actually handled are handled differently. Of course, any of these properties might be held inside of a condominium association type situation, and that adds an additional layer, because now you're dealing with a condo association being the entity that has the fire policy, and that adds a new dimension and a complication. For renters, they have the same problems that all the rest of people who own property have, except they don't have the property ownership situation, but they do have the contents issues. So they could have a casualty loss possibly on their contents if they don't have insurance, or they're way underinsured, or they might have an involuntary come under Code Section 1033H1 as to their contents. And as long as it's just the regular contents, not scheduled property, basically all those proceeds are tax-free. But they still have to deal with anything dealing with the additional living expense, keeping track of what they're getting versus what they're spending. I'm going to turn it back over to Dennis to talk about insurance.
Yeah, I'd like to sort of set the table for John going forward. And unfortunately, I have become quite familiar with the various types of coverages in my homeowner's policy, and all the terms that describe those coverages. As many of you have experienced, some people got paid out right at the beginning from their insurance companies, but many of us have had to engage in this difficult process where we become familiar with people such as public adjusters and insurance attorneys who handle these matters. Exactimate was not part of my vocabulary before this process, but I've since learned that insurance companies use the Exactimate program to calculate the rebuilding cost of your house. For some reason, they come in quite low, so that's an issue that many of us are dealing with. But in terms of coverages, we have, depending on your insurance company, Certainly, coverage A and B are related to the dwelling. That should be amounts that are provided to rebuild your house. It also covers something called extended coverage, which on my policy is a percentage of the dwelling coverage. Um, Covers trees and landscaping, shrubs. That's a separate category within A and B. Um, Also, there's additional other structures like fences and jacuzzis and pools and that sort of thing. Um, Under these coverages, there's debris removal, so the cost of removing the cost of removing any other structures, and then ordinance and code and ordinance is what they call it uh, in my policy. That's to provide for the cost of rebuilding at current codes and ordinances. The second or the third one is contents. That's personal contents for what you lost in your house. That's non-taxable. And D, and I'll say generally non-taxable. And D is ALE, which is additional living expense, which covers your rent while you're waiting for your house to be rebuilt, covers a hotel that you stayed in the day of the event and perhaps thereafter, and Airbnb charges and that sort of thing.
And Dennis, I think you said before that people should check their individual policies because they might have slightly different coverage. Is that correct?
Yes, they really should, because there's a lot of discussion on Nextdoor and other similar sites about certain things, and it's some of these things are so specific to the what's in your policy. It's really hard to generalize. So yes, absolutely. Have you or your professional check your coverages before you start making decisions.
Dennis, I would also add that in some cases people have expensive, excuse me, artwork or jewelry, things like that, that they have a rider on for, we call it scheduled property. And when we're talking about our gross proceeds going forward and the rest of moving on, as we move on here, that scheduled property is treated separately from the rest of the contents and is actually added to the proceeds for the real property. And any cost basis associated with that scheduled property would also be added to the cost basis of the real property.
Yes, good catch. John, go ahead.
Okay. Okay. Well, kind of a dancing around this, but when people settle down after they take a deep breath from the fire, I think most people think, do I have a casualty loss deduction here? I know that I think back from my own experience of the Northridge earthquake. My first thought was, do I have a casualty loss? Now, I was totally wrong on that. But I'm just saying that it's a natural thing for people to jump to that conclusion. And I think most situations, it's tough to come up with a casualty loss, either because you've got maybe a very low old basis going back to maybe the 90s or maybe the 70s or even before that. And even though the insurance has not kept up with current loss possibilities, it still exceeds the cost basis, and therefore it eliminates the possibility of a casualty loss.
So John, I have a quick question about that. So let's say I bought my house way back when for $800,000, and now it's arguably worth $3 million, but I only had coverage maybe to 1 million. You're saying that the casualty loss is going to be based off of my cost basis, the 800,000, and then we can deal with the insurance later. But you're saying that's what people are going to grapple with.
Right. So if we don't have a casualty loss, then we have an involuntary conversion deferred gain. And so the casualty loss is covered under, for those who are technical, want technical, casualty loss is dealt with under Code Section 165, and the involuntary conversion is dealt with under Code Section 1033. And there are various pieces of 1033 that apply to different situations, as I mentioned before. And we're going to be concentrating on the primary personal residence as opposed to the rental property, the personal, the second home, or the commercial. So once we've identified, so how do we identify which one of those situations we're in? Well, we have to start out with our cost basis, as Megan just pointed out in her example, the cost basis of $800,000. And then the next thing is, what are the proceeds? Well, proceeds can be tough because we have all the categories that Dennis was talking about, but then we possibly, in a lot of these situations, and in both of the fires that we're talking about today, we have lawsuits against third parties. And so that may lead to additional proceeds. So that may delay our understanding as to whether or not we have a gain or a casualty loss. But we need to get those two numbers tied down. And once we have those two numbers tied down, then we can say, oh, okay, geez, our proceeds are way less than our cost basis. So maybe we have a casualty loss here, in which case then we're going to need to get appraisals of the fair market value before and after. And this is kind of I think of it as a nanosecond apart technically, because it's the fair market value immediately before and immediately after that we're looking for. The appraisers that would be dealing with the before, that technically that's kind of like just a normal real estate appraisal, except that they'll probably have to put in language in their appraisal that's, quote, a hypothetical, because the physical house no longer exists. And that's okay, but there are other requirements that the appraiser needs to put into the appraisal to satisfy the IRS. And the one after, they need to take into consideration the impact of the debris sitting on that lot, because it is immediately after. And so the debris does have a decrease of a reduction in the value. But again, as Dennis was mentioning, we have this problem with the temporary buyer resistance. And that's not a number that we really know at this point in time. So I think it's going to be tough in some cases to really come up with a good appraisal.
John, can I
Sure.
answer a couple of things? Just with regard to a casualty loss, as John was saying, that the casualty loss would be based on the lesser of the adjusted basis or basis of your property, and then or the decrease in fair market value immediately before and after. Also, any amount that you might consider claiming as a casualty loss is reduced by the insurance proceeds that you have received, or according to the statute, that you expect to receive. So that further counts against the amount that you might want to claim as a casualty if you're considering it. John did mention the fact that if you're involved in a lawsuit, that's called that basically keeps it an open transaction. That is, you can't claim the loss until everything is concluded. All your claims have been dealt with.
Settled. Yeah.
Yeah, and so what John was alluding to is that certainly if you've lost your house, that loss is easily proven because it's gone. All you have is dirt. But if you want to go the fair market value immediately after, and you want to claim that your entire property, including the ground, has been reduced. And I can tell you what I have read is that lots are selling for something in the neighborhood of a 45 to 50% discount from before the fire when you compare to current sale prices. Now, you have to be careful about including that in a casualty loss, because the cases say that if a reduction in fair market value is due to general market decline, or it's due to buyer resistance because of something like a fire, then that's considered temporary. And it must be permanent before you can make it part of your casualty loss claim. I know this from my own experience because I've tried cases involving Brentwood property that was the value was impacted by O.J. Simpson affair. It's kind of an interesting case. It's an interesting read. It's public record. It's called Chamales, Chamales versus
Yeah,
Commissioner.
I love talking about that case.
And also, I handled a case involving someone who owned oceanfront property in Malibu. Uh, in both those instances, I found that the tax court judges were quite clear about wanting to make sure that the casualty loss was in fact permanent. It's hard to prove a casualty loss in an area where the property values continue to go up after the casualty has occurred. I've also handled a matter in Santa Barbara, the same issue. So anyway, I caution people who want to claim a casualty loss. And what John is about to present are um, probably more realistic ways to deal with this, unless you.
Yeah, and
Yeah.
I think John is also going to kind of talk about something that people have been asking questions about, which is the time frame that you have to claim certain things and file certain things.
Yes, very important.
Including with the casualty loss challenges.
Okay, so if we don't have, if our proceeds exceed our cost basis, then we have the involuntary conversion situation, and we're not really concerned with the appraisal, so it's not money you want to spend. But then we have to deal with all of the replacement costs and matching up the replacement costs against the proceeds. So we've been talking about, Dennis has been mentioning, I've been mentioning a little bit, but Dennis has been talking quite a bit, the idea of the temporary buyer resistance and the fact that when we're claiming a casualty loss, at this point in time, it may be premature. And in order to claim the casualty loss, the code says that the loss must be sustained. And in order to be sustained, not only has it physically occurred, but all claims for reimbursement have been settled. And Dennis has talked about that. So I'm not going to spend I've got several slides here, but I'm not going to spend too much time on it because we've talked about it. But, some indication.
That means if they haven't gotten their insurance payment yet, or if the insurance is staggered or delayed, or also if there's a lawsuit, which I know there is in some of these fires, that could be a challenge timing wise. Is that correct, John?
Right. The lawsuit is the challenge. So indications that it's not settled. Lawsuit there's a lawsuit outstanding. Also, what's happening with the lot? Is the lot going to be sold? And that may be different from the calculation that's used in the 4797, 4684 calculations. And also there may be decisions about selling the property. So I'm going to move ahead to first example. And this example is, this slide is based upon the format of the 4684 and lines 2 through 9. And line 1 is the description of the property. So this is the immediate decision that the taxpayer might make in this situation. They've got a cost basis of the property of what do I have? 2 million, yeah, $2 million. And they receive $1.5 million from their insurance company. And let's say that's all they're going to receive. There's no lawsuits. They could keep it nice and simple. So it looks like pretty clean situation. So they've got $500,000 of cost basis that they have not absorbed with the insurance proceeds. So they go out and they get appraisals. And I'm going to stipulate that these appraisals are quality appraisals. They're defensive, they're defendable, and that's not going to be an issue. So the appraisal before says that the property is worth what's it, $4.5 million, and the value after is $2 million. So we've got a decrease in value of $2.5 million. So $2.5 million is greater than our cost basis of $2 million. So we are limited to a casualty loss of $2 million, the lower of the cost basis or the decrease in fair market value. So we start out with the $2 million, we deduct the $1.5 million of proceeds, and we now have a casualty loss of $500,000. And, that's a pretty good deal. You might save the client maybe as much as $200,000, puts $200,000 in their pocket to help them rebuild their lives. Sounds like a good deal. But here's what happens later. 2.5 years later, they sell the lot for $2.5 million. Well, the cost basis of that property is zero. Now, it might be a little bit more because of some debris clearance money that's created some new cost basis, but I'm going to ignore that because it's pretty minor overall, probably. So we have a $2.5 million sale, and what are they facing? They're facing a capital gain, state and federal, as much as $750,000. So now they are in the hole $550,000. Question is, can we do something better? Well, if in fact we start out and we say, geez, you know what? We're not going to claim a casualty loss. So we start out with our cost basis of $2 million. We receive $1.5 million in year one, or year zero, maybe the 2025. But we say, okay, well, we think we're going to end up with an involuntary conversion here, so we're going to report it that way, even though we don't have a gain at this point. And at this point, we would not make any elections as to deferring gain because we have no gain to defer. Because one thing you need to be aware of is once you make that any gain deferral and there is a gain. You don't have a choice. You cannot change your mind. You cannot revoke the election.
And John, you have this time period of 4 years to replace the property, but that's for their main residence. That's not for other tenants.
Okay, well, that 4 years has not even started.
Okay,
because
perfect.
we don't have a gain. Just to comment on what Megan is saying, the 4-year rule is that you have 4 years. If you have a gain, you have 4 years to replace the property. But that's you have a period that started on the day of the fire and extends 4 years past the end of the first year in which you have a gain. So if you don't have a gain until, let's say, 2026, then you've got until 2030 to replace the property, because it would be 4 years from the end of 2026. In this case, we have our $50.5 million, and within 2 years of the fire, and this is 2 years of the fire, not 2 years of the end of the year, but 2 years of January 7th, my client sells in this example, sells the property. Now, remember, in the prior slide, they sold the property 2.5 years, and they sold it for $2.5 million. Well, in this situation, they're selling it a little bit earlier, so they're not getting that full 2.5 million. They're only getting $2.2 million. Again, it's all hypothetical. So our total proceeds are $3.7 million. And so we make the election to defer the gain. Because we sold the land within 2 years of the fire, 2 years of the date of the fire, we get to use Section 121, and assuming that this is a married couple, we get to exclude $500,000 of the gain. But that has to take that, if any portion of the gain that is subject to possibly to the $500,000 is due to the land sale, then it has to take place within 2 years of the date of the fire. So that's what we did here. We got $3.7 million of proceeds, less $500,000 of Section 121. And so we've got proceeds of $3.2 million that need to be reinvested. And we've got a gain of $1.2 million that we're electing to defer.
And John, you made a really good point. You said it has to be done within a certain time period. What happens if it's not done within that time period?
Or you just don't get any gain related to that land sale. It cannot be used in terms of calculating Section 121. Now, that may not be a problem. I mean, in this case, these people, in addition to what's happening here, and I've eliminated that, but just adding another dimension, they may be involved in a lawsuit. And so maybe 3 years from now, they settle a lawsuit, and part of that lawsuit, they get $2 million additional proceeds for the real property loss. That $2 million, even though it's happening 3 years down the line, can be used as part of the proceeds against calculating the 121 exclusion. But I don't have that twist involved here.
And I just wanted to make one comment, and that is this 4-year period that starts running on December 31 of the year in which you receive insurance proceeds that puts you in a gain position is basically, that's the time that the code allows you to reinvest those proceeds and defer the gain that you otherwise would have had to report from the receipt of the insurance proceeds. So it's a gain deferral that is held for 4 years, so you can rebuild or reinvest in a new house. And once you do that, then you're good, right? Unless you have a pending lawsuit and get more proceeds.
And I just want to add, if that 4-year period applies for primary personal residence, and if we were talking about a second home, a rental property, or commercial property, instead of 4 years, it's only 2 years. The other thing that I want to emphasize is that that gain is after computing any 121 exclusion. So we may have a proceeds that exceed our cost basis at the end of 2025, but applying the 121 exclusion gets us down below, we don't have a gain, in which case then the 4-year period is not started.
Okay. And let's assume you are in a gain position and you're coming up to the end of the 4-year or the 2-year period, whatever applies. Can you request an extension of that period?
You can apply for an extension. It's not like we apply for an extension on a tax return where we fill out a half-page form and submit it and thank you very much. It's a process. I won't spend time on it, but it is an application process that and all those applications go at this time. They kind of move them around. I mean, 4 or 5 years ago, they went to New Orleans, and then they went to Houston. Now they're going to do an office in Detroit. And there's one central place where they're evaluated by the involuntary conversion coordinator's office. And
Okay.
and there's no limit on the number of extensions that you can request. I've got a few cases. I'm trying to think. I've got at least one case where I'm about to ask for the fifth extension. And if you're showing progress, if you've got good reasons, I've never had a problem with the office denying the application. One thing I want to note is that this is a very unusual area of the Internal Revenue Code. Unlike most areas of the code that are designed to pick our pockets, this area is designed to keep money in our pocket, and in the case of the casualty loss deduction, actually put money in our client's pocket. So, and the IRS has been mandated to interpret the rules to the benefit of the taxpayer liberally. So, even on the extensions, the extension needs, if I was looking for an extension at the end of this year, that extension should be put in by the end of December. But if I don't make it by the end of December, that's not the end of the world. There's a couple of provisions that if the reason is reasonable and the time period is reasonable, they will evaluate the extension. And I've had some extension requests that the time period I thought was kind of crazy, but I put the extension request in anyway, and we got the extensions. So getting back to our situation here, so we've got we've now taken our money and we've taken we actually have $3.7 million, and the taxpayer has reinvested the whole $3.7 million. They've got the deferred gain of $1.2 million that gets reduced against the cost basis of the replacement property, and so the replacement property has got a cost basis of $2,500,000, which is that $500,000 is greater than our cost basis that we started out with of $2 million, because we used all of the proceeds, including the portion of the proceeds that we got to exclude. So we spent more money. And if the taxpayer spent $4.2 million, well, then their cost basis would be $3 million going forward. So the point that I want to make here is that you have to think long term in planning as to what the client is going to be doing, and what the clients, you don't want to be short-sighted in terms of making decisions, because they can be costly. In this case, even though the taxpayer got $300,000 less for the lot than they did by selling the lot later, they actually ended up with more money in their pocket to actually reinvest in the replacement property. I'm sorry, I didn't advance the slide to this one. So this was the last slide where they spent the $3.7 million, and they've got the cost basis going forward of $2.5 million after offsetting the $1.2 million. I want to go over emphasize this whole thing about premature deductions or deducting. This is actually a case out of my files. These people were retired folks. They lost their house in a 2007 fire down in San Diego, and they went to their tax preparer, and the tax preparer looked at and somehow came up with a casualty loss, and they saved $5,000 on their 2007 tax return, and they carried forward the loss 2008, 9, and 10. So in each of those 4 years, they saved approximately $5,000 for a total savings of $20,000. Well, in 2011, they settled the lawsuit against San Diego Gas and Electric and went back to their tax preparer in early 2012 and said, well, what do we do with this? And the tax preparer sent them to me. So I looked at the situation and I started out, well, what does the code say? Well, there is a provision in the code, section 111, recovery of prior losses. Okay. And in applying section 111, we now look and say, well, what are the proceeds that we got from the lawsuit? I don't remember what they were, but they were substantially more than the tax deductions that the taxpayers got in those 4 years. So we had to add up those tax deductions that they got in those 4 years, and all of a sudden that became taxable income in 2011. So in addition to their normal $5,000 tax liability that they would have had for 2011, they had an additional $48,000 liability due to the recovery of those prior losses. So basically, it cost them $28,000 of quote interest to borrow that $20,000 from the FDB and the IRS. That's where we started. Megan, go ahead.
I want to add something because we had a question about what a casualty loss is, and I want to make sure that because we have varying degrees of expertise on this call. And so, first of all, obviously, as you're going through this, you can see how complicated it is. But a casualty loss is a specific Internal Revenue Code provision that allows for you to take a loss when you have a financial loss or damage to property that occurs suddenly or unexpectedly, and it's due to events that include things like natural disasters, fires, or theft. And so it's a specific tax code provision that people sometimes use. And obviously, John's an expert in it. But for those who are kind of trying to figure out what we're talking about, that's.
Okay, thank you. So, given that big number for them, $48,000, I looked a little bit different. Looked at the situation a little differently, and I said, well, let's go back to 2007. And so I asked the folks, I said, well, when did you file your 2007 return? They said, oh, we filed that right on time in April of 2008. I said, oh, okay. And when did you join the lawsuit? Because I'm thinking, well, maybe they didn't join the lawsuit for a year or two later. And he said, oh, no, we joined the lawsuit right away in 2007. I said, oh, well, now I go back to section 165. And remember, I said that in order to claim a loss, the loss has got to be sustained. So I told them, I said, because you joined the lawsuit prior to filing that tax return, your loss was not sustained. You were not entitled to claim that loss on your 2007 return. So what we did is we prepared the report of involuntary conversion for 2011, showing the deferral of the gain, ignoring the casualty loss, and then went and made those reports also going back to 2007, and amended their tax return for 2007 and eliminated their casualty loss. Now, if anybody's counting statute of limitations, the 2007 return was filed in 2008, and the statute would have told in 2011, and they're talking to me in 2012. So how can I go back and amend 2007? Well, once we have an involuntary conversion, all of the years are open. So we were able to have them pay back the money in 2007, 8, 9, and 10, which they happily did because it was cheaper than paying $48,000. And we didn't hear from the IRS. I actually had two cases like this, one in 2007 fire and one in 2008 fire, and did the same thing in both cases. So there's the possibility. Now, had this client listen to my presentation today and had all the information. So now, unfortunately, all of you are tainted. You can't use this excuse because you now know the rules. But that was the
If they understand the rules, John, the rules are
if they
pretty
understand the
complicated.
rules. Yes. Okay. So let's see. This is now I want to talk about another really special situation that applies to the primary personal residence. And this is the fact that the replacement, what is qualified replacement property? And qualified replacement property is not only includes any replacement personal use residence, but also includes contents, personal property. And so I've got an example of how this works. And I'm going to have two results to demonstrate a couple of items. But like we start out with the same fact situation. We've got a cost basis of $800,000, and we get proceeds of $1.7 million. So we've got a $900,000 gain. Well, we get to use our $500,000 exclusion, so the $1.7 million comes down to $1.2 million. So we have proceeds of $1.2 million versus cost basis of $800,000. We've got a gain that we're electing to defer of $400,000. So what did we do with that money? Well, what we did is we spent $1 million on rebuilding the house. Maybe a more modest house. I'm considering we got $1.7 million for the original, but I'm going the minimalist one in this example. So we spent $1 million on the replacement real property, and we spent $250,000 on personal property. So this is clothing, shoes, socks, linens, furniture, toaster ovens, dishes, anything of a durable nature, not the consumables like toothpaste and food and such as that. So $250,000. We spent a total of $1,250,000 on qualified replacement property. And so our first test is we needed to spend at least $1.2 million. We spent $1,250,000. So we've satisfied the first requirement. Second thing though is now we have to deal with that deferred gain. Well, the deferred gain gets allocated over the various replacement properties. So the contents, the personal property amounts to 20% of the $1,250,000. So $80,000, 20% of the $400,000 deferred gain gets applied to the contents. So now our personal property moving forward has got a cost basis of $170,000. But what's included in there? I've already mentioned what's included. It's nothing that is going to appreciate. So that $80,000 will never get taxed. Now, let's say just for an example, let's say that in that 250, let's say there was a piece of artwork that they acquired for $50,000, 20% of the 250. Well, then 20% of the $80,000 or $16,000 would be applied against that piece of artwork, and they would have a cost basis on that artwork going forward of $34,000 that they would need to keep track of in case they ever did sell it in the future. But so far, we've allocated $80,000 to the contents, leaving $320,000 to allocate to the real property. So the house going forward has got a cost basis of $680,000. And we're done. Okay. But now let's take another possibility. Let's say that they spend on replacement property $2 million on the real property and $500,000 on the personal property. Again, an 80-20 split. They spent $2.5 million. And the first question is, where did they get $2.5 million? Well, we know that they actually got $1.7 million for the real property, not $1.2 million. They actually got $1.7 million. And if they got $1.7 million, it's very possible that they might have gotten as much as $800,000 for contents, giving them a total proceeds of $2.5 million. So this is not that outrageous of an example. So again, the $500,000 of contents, we reduced that by the $80,000, 20%, and the house, the $2 million, we reduced that by the 320, and so the house has got a cost basis, excuse me, going forward of $1,680,000. So these taxpayers, using only insurance proceeds, started out with a house with a cost basis of $800,000 and ended up with a house with a cost basis of $1,680,000. So and we got rid of, for all intents and purposes, ever having to worry about taxes on $80,000 of the deferred gain. There's a thing that I want to bring to your attention regarding something called the deemed election. This is a situation where taxpayer totally ignores the tax law, does nothing. They don't make any casualty loss claims. They don't report any deferred gains. They just take the money. They probably did the right thing. They probably reinvested it, but they didn't report anything to the government. So the question comes up, well, if the IRS finds out about this, what's the outcome for the taxpayer? Well, again, remember that the law is written with the idea of being pro towards the taxpayer. So the assumption could be, well, that gain is taxable. Well, that's not being very pro towards the taxpayer. So instead, there's this deemed election. And basically, if there was a gain and no reporting was done, then the tax law, in effect, makes an election for the taxpayer to replace the property, defer the gain. One of the problems is that there's no deemed election with regard to the replacement costs. So the taxpayer still needs to, when it comes to light, maybe it's a couple of years from now, still within that replacement period, and they've been doing all the replacements, et cetera, correctly, they have to go back and amend their tax return, report the gain, do the involuntary conversion reporting, and now we have the problem with the replacement property. If it's a primary personal residence, it probably is not too much of a problem. There's a private letter ruling in 2012 that dealt with this, and basically the IRS gave the people a pass, basically saying you did everything right, you just didn't tell us what you were doing, but within the required time period, you caught up and got it all done. We'll let you do it this time. Don't ever do it again, kind of thing. If it's a commercial, or especially if it's rental property situation where the taxpayer during that replacement period has acquired multiple different properties, any or all of which might qualify as replacement properties, that becomes a problem. There's a 2001 field service advice on this, where basically the IRS just hung the taxpayer out to dry, to be honest with you. So this is something you don't want to be in a situation where you're stuck with a deemed election. You want to start off by following the rules from the very beginning. Another set of concerns. It happens. There's divorces. There's deaths that happen after the fire. And how are these treated for in terms of the tax law. Well, the divorce is fairly straightforward. Basically, you split it into if the property got split between, well, California's a community property state, so the transaction basically gets split between the two parties, the husband and the wife. Now, what I've seen is in these cases is the cost basis and the proceeds are split 50-50, and each person goes out and buys their own replacement property. I've got one case where the parties actually acquired one replacement property that the husband continues to live in with the children, and at some point when the children are and so they both have an interest in that house, and then at some point in time when the children are out of the house, then the house will get sold and they'll split the proceeds, but that's a separate transaction. But they're continuing to hold it hold it jointly. If you have a client that has a QPRT or a PRT, qualified personal residence trust or a personal residence trust, there are additional rules that come into play. They are a little bit onerous. They are doable, but they are onerous. There's instead of a 4-year replacement period, it's a 2-year replacement period, and it's a 2-year replacement period for the QPRT that starts on the date of the fire. And you may not know all the numbers within that period of time, and there are no extensions as far as the QPRT thing, and people want to maintain and don't want to break that QPRT, so they're kind of forced to go out and maybe overbuy replacement property in order to lock in that they're okay with their QPRT. The last thing on this screen is I want to deal with the entity, and that is that it is the entity that is dealing with the transaction. So let's say it's a piece of rental property, and you have two partners that own 50% of the property, and after the fire, they can't agree as to whether or not they want to replace the property or just pay the tax and move on. Unfortunately, they can't split the transaction. The decision has to be made at the entity level. So they may have to buy two separate properties that qualify, maybe as close to 50-50 as possible. And then the one that wants to cash out then later takes his property and then sells it. But they don't have a choice as to taking the money and splitting the money and going their separate ways. It has to be dealt with at the entity level. This is an example of what reporting might look at, and I want to point out that, and should have said this up front, the IRS does not have a form to report an involuntary conversion. Apparently, it's more difficult for them to figure out. I don't know how many parts of the Internal Revenue Code that don't have forms to go with them, but involuntary conversions is one of them. And so there are probably about, depending on how you count, 20 to 30 items that need to end up getting reported in a report of involuntary conversion. And and also these reports are what I call episodic, because you're making a report to the Internal Revenue Service and the Franchise Tax Board annually, telling them what you've done, what's happened up to that point, and telling them, here's the proceeds that I've received cumulatively, and also here's the proceeds I've received this year. Here's the money that I've spent on qualified replacement property cumulatively, and here's what I've spent this year. and how did I spend it? What are the where's the, now, when it gets down to that contents thing, you don't have to tell them every spatula and pair of socks but you need to maintain the detail of what was included in that number.
So I know we can go over a little bit, but we unfortunately are going to have to end the program quick because that's all that the platform can handle. So John, I'm going to let you close out in a second because as Dennis said at the beginning, you're kind of the star of the show. But I do want to just quickly point out that we did get a lot of questions. And as you can see, it's a really complicated area and it's very fact specific to that person. So I would just urge people to reach out to one of us to follow up on those questions because unfortunately we won't get to them during the program. So John, I'm going to let you and Dennis close up, but I just wanted to say thanks to you both and to our audience.
Okay. Well, thank you for attending. Thank you, Dennis, and thank you, Megan, and thank you, Terry, for making this presentation possible. I think it's an important piece, and I think the importance of the presentation is evidenced by the fact of so many people joining in on the session. So thank you all for attending. Dennis?
And it's been again, it's been a privilege to be on the panel with both of you. I wish everybody who is listening the best of luck. It's going to be a bit of a long haul for all of us, but I'm sure we'll get through it. And please don't hesitate to reach out to the professionals who can help you best. And I have to say that John is one of the gurus in this area. So
John's impressive. His knowledge in this area is impressive. Dennis and I have spent a lot of time with him, and I think we both walked away very impressed. And Dennis, you actually know quite a lot of sports.
yeah. So anyway, best of luck to everybody.
Thanks all.
Thank you.